Oh, hey folks, Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Great question today from a subscriber to our YouTube channel. Hey Patrick, how to avoid common mistakes with estate planning with IRAs. All right, folks, as I was saying here under number 3, employment change, you need to take the responsibility to get written verification from your employer that your beneficiary designation was updated properly. Number 4, folks, people naming minors. You never want to name a minor as a beneficiary of your qualified retirement account or any asset for that matter. We had a case not so long ago. A friend of mine's mom was in a nursing home. She passed away, and unbeknown to the family, she named on her retirement accounts her grandchildren. Not good, because the financial company cannot give a check legally to a 10-year-old. So they said to the parents, oh, you need to petition the probate court and become appointed by the judge as your 10-year-old child's conservator, and then we'll cut the check to you. You need to name your trust, more specifically, the bloodline trust. And then you would pick out a trustee, could be your child, who's going to manage the money for the benefit of your grandchild. But that needs to be in writing. You need to create that in your trust first, folks, with your estate elder law attorney. All right? That's step 1. Same concept. Do not ever name a disabled adult as a beneficiary of any asset, because now that's going to likely jeopardize their means tested public benefits. They could be receiving Medicaid for their medical care, right? As well as their housing. And typically those means tested public benefits, they cannot be over $2,000 in assets. Now they're receiving an inheritance, and that's now going to jeopardize and knock that child off their housing and medical benefits that they so badly needed. So the only option, the government gives us an option to create a first party special needs trust, also referred to as a D4A trust, a D4A trust. The better strategy, and I have other videos on this, is you need to do it in advance. You create a third party supplemental needs trust, because a third party supplemental needs trust does not require government payback. And it will continue to allow your disabled loved one to receive their government benefits for their needs-based care, and the funds being paid to their trustee of their third-party supplemental needs trust. Folks, that's number 4. Number 5, not naming the family bloodline protection trust. When we create a trust for clients, we create asset protection in our client's trust, because our clients, Bill and Mary, say, Patrick, we worked hard for what we have, and our children's are names Mo, Larry, and Curly. What if they encounter times of turmoil? What is that? Auto accident, lawsuit, divorce, in-law turn into outlaws. How much of their inheritance is at risk? Could be all of it, or at least 50% of it in a contentious divorce proceeding. So in comes the true and tried Internal Revenue Code asset protection language you want to put in the 4 corners of your trust. It's called ascertainable standards, the HEMS standards right here. HEMS, health, education, maintenance, and support, limited testamentary power of appointment. That's the legal ingredients that needs to be in the trust to give your loved ones a protected gift, to give them asset protection, folks. That's often not done either. And think about it, your 401k, your IRA, your qualified retirement account, you've worked decades for it. You do not want to risk losing that when you're up in your cloud someday. Number 2, we preserve the value, right? The $1 million or whatever it is. And the third P, we pass it on as a meaningful legacy without it being squandered or jeopardized or lost back to the government or potential financial creditors and predators. Folks, 5 common mistakes with IRAs and other qualified retirement accounts. I'm going to give you a bonus piece here as well, folks, and it's the Secure Act. Secure Act governs qualified retirement accounts. Folks, Secure Act 2.0 says now you don't have to start taking those required minimum distributions until age 73, okay? So you want to let the money sit there as long as you can, let it grow tax deferred. And then when you go up to your cloud, typically the beneficiaries, say the children, they have a 10-year rule. They have to take all those funds out within 10 years is the general rule. If Mo, Larry, and Curly are all getting $100,000 each from mom and dad's IRA, it would be in their best interest from a financial standpoint not to touch that money, to take an IRA rollover and let that money grow tax deferred over the next 10 years and then pay taxes on it maybe in year 10 if it's so allowed, right? But work with a qualified tax professional, CPA, tax attorney, estate, elder law attorney that knows the rules of engagement when it comes to the Secure Act. Folks, hopefully you found this video helpful. Please post a comment or a question. Please click the subscribe button and share this video with other folks that you think could benefit. If you'd like to read, pick up a copy of my book on Amazon. Patrick Kelleher, How to Slay the Four-Headed Beast, Estate Planning in Elder Law. My second book is just finished. That'll be released very soon as well, which is the top 20 elder law questions. I hope you like it as well. Folks, thanks for joining us here today at elderlawcare.com.